KFC of Kansas versus Rebecca.
Mark Carr is appearing for KFC of Kansas.
Okay, well, Miss Justice, this is not a new case, as we all know. It's been around, as the caption suggests, since 2001. And there was recently, as of April 7th, 2025, an order issued for garnishment based on a judgment taken against you some years back. That was order of garnishment for Walgreens payroll department. Are you an employee of Walgreens payroll?
Yes, ma'am.
And you filed an objection to the garnishment, as I understand.
Yes, ma'am.
And what is the basis of your calling for this hearing and objection today, please?
It's past the statutes of limitations.
And what are those statutes of limitations as you believe them to be?
From what I've read, for Kansas, it is 7 years for written contract and 3 years for oral contract, along the fact that I also read that there's a special distinction in Kansas law stating that debt collectors and debt buyers cannot garnish somebody's wages.
And what's the legal authority you're relying on? Is that case law, statutory law, both?
That I am not sure. It just says Kansas state law.
And what are you reading?
It was off of Upsolve.
Upsolve?
Yes, ma'am.
SOLVE? All right. So, Mr. Carrs, your response to this motion for dismissal on the grounds that the statute of limitations prevents enforcement?
Well, first of all, Your Honor, we have a lawful judgment that was entered back in September of 2001. The previous lawyer that handled this account for KFC of Kansas, Dean Homolka, timely filed renewal affidavits and kept the judgment active and alive. We've continued to do that as well. I believe we filed one. So the judgment never went into default, never went into dormancy. And so the judgment's active. It's been kept active. This account was never sold. We don't handle accounts that are sold. So it's still retained by the original creditor, KFC of Kansas. So we'd ask that her motion be denied, Your Honor.
The motion is denied. You might want to research a little further if you
want to see it.
If you don't understand, ma'am, because this is a judgment on a debt. It's not, they're not just now filing it. They did file it earlier. They took judgment. Counsel pretty well slimlined exactly what the points are that the court has to consider in these kind of issues. And I deny your motion. I think it's without merit. I find it is without merit at this time.
And what is the total amount that is supposed to be owed?
We have an unpaid balance, Your Honor, if I may answer that.
I
We
would
have
ask
an
you to.
unpaid balance today of $371.47.
Okay.